All right, terrific. Well, welcome everyone. Thanks for your patience. We're going to get going here. This is, of course, the sexiest panel of the seminar. And will indeed be one of the most talked about topics in the upcoming years. For brevity, we're just going to move along and do our self-introductions, folks, if you don't mind, and you can tell people something about yourself that you might make sure that you'd like them to know about yourself. Very briefly, I'm the moderator. My name is Ken Abdo. I am a senior partner in the Minneapolis-based law firm of Lohman Abdo. We have an office in New York, a very charming office in Wisconsin, and Minneapolis. I'm primarily a music lawyer, not exclusively, and we have 7 entertainment lawyers in our firm of 40 lawyers. My claim to fame here, if there's any, is, well, I was a former chair of the ABA, but also I was notified that my filing on the termination rights for the sound recording for the song Funky Town, which is my song, well, I represent the song, was the first filing. And I didn't know that at the time, but that qualifies me, I guess, to be moderator. And I have here some very heavy people, some serious minds, and we're going to talk about the termination of sound recording copyrights. We're going to try to stick to the description that was in your pamphlet, and we're going to let each of these people air it out, so to speak. So we're going to hand it to Ann, who's going to introduce herself, and then move down the line.
Hi, my name is Ann Chadovitz, and I'm the Executive Director of the Future of Music Coalition. The Future of Music Coalition is a nonprofit think tank that seeks to educate musicians, the media, policymakers, and the public about music and technology issues. We work in really 2 areas, first being compensation issues, and that includes things like health insurance, copyright, contract work, obviously things like work for hire. And the other area we focus in is media issues. We want to ensure that musicians have access to get their product to the public to create fans. And actually, I periodically, because I know this is a hot topic, check, do a search of the Copyright Office records to find out if there's been a notice filed. And I called Ken. I was like, Ken, I see that you're the person who filed this notice of termination on Funky Town. So that's even how you knew you were the first one.
It's amazing.
Small world. And I was, because I'm like, I know him. So anyhow, I'll pass it on to Jay now.
I'm Jay Cooper, and I understand Ed Pearson said everything there was to say about me at lunch, so I don't have to say anything.
God, I'm sorry I missed that. You see, this is why you should get her for the lunches, but traffic. Anyway, I'm Mark Goldstein, and when the ABA originally came to me asking me, the organizers, if I would speak on this panel, they presented me with an impossible task, which I'm glad to see that Ken and everyone else has modified. But since I spent a lot of time working at record companies, mostly Warner Brothers Records, running business affairs there, I guess they felt like I would be the voice of the evil empire in talking about works for hire and termination rights. And it may still work out that way, but I don't think it will. I left Warner Brothers about 4 years ago and spend most of my time teaching. I teach at the music school and the music industry program and at the law school at USC. I also continue to do some consultation and legal work, mostly, however, for game companies and advertising agencies who have money and are interested in music, and that's different than some of the people I used to work with all the time. So it's been interesting and educational, and for those of you who are thinking about doing something in music, something to bear in mind.
Okay, I'm David Nimmer. I am of counsel to the law firm of Irell & Manella here in Century City, which does represent a number of record companies, but I'm not here in that capacity. I'm here in my alternative role as a professor at UCLA who teaches copyright and who writes extensively about the field of copyright from all angles, not simply music.
All right, thank you. We're going to do a bit of background, and we're leaning on Ann, who wrote a very great article about this topic. And we're going to ask you to lead us off with a discussion of the legal context of the panel, followed by the pre-amendment law concerning sound recordings and work for hire as set forth in your article. And if you could explain the current statutory basis for the termination right and work for hire exception, please.
Okay, so I have the really boring, dry task, so bear with me. And all the things that I quote or that I refer to, they're all in your materials, so don't worry if you don't get it. You have it in the materials. So first I'll start with the definition of work for hire, which is defined two ways in the law. The first prong is the work that's prepared by an employee within the scope of their employment. An example of that would be a computer programmer that's working for a software company on staff, goes in every day while the software company owns the computer programs that they create. Now, because that's created in the scope of their employment. If they're at home on the weekends writing a book about computer programming, software company would not own that. Now, the second prong is a specially ordered or commissioned work in one of 9 categories that's specifically enumerated in the copyright law if there is a writing designating it as a work for hire. So there needs to be a writing and it needs to be in one of the 9 categories. The categories listed are the kinds of works that often have numerous authors, things like a movie or a textbook where everybody gives a little section. Importantly for this discussion here today, sound recordings are not an enumerated category. And agreeing that something is a work for hire does not make it a work for hire. You have to agree in writing that it's a work for hire, and it has to be one of the categories. So just your agreement does not make it a work for hire. Now, recording artist contracts generally have 3 things. They have, first is language that the artist is an independent contractor, not an employee. They also have language that the works are works for hire. And then, record companies use belt and suspenders. They say, and if it's not a work for hire, the artist is transferring the copyright in the masters to us. So here, our question that we're confronting today is a sound recording a work for hire, and why does it matter? Well, it matters because the copyright law contains a termination provision permitting authors and their heirs to terminate all transfers or licenses of a copyright that were made by the author after 35 years. Now, why do we have this? This was a policy decision that Congress made specifically to give authors a second bite at the apple, because in the area of intellectual property, people don't really know the value of a work until after the work has been exploited. So Congress put this in specifically to protect authors and to give them a second chance. Now, Section 203 of the copyright law, again, you have this, applies to transfers executed after January 1, 1978, and 35 years after that takes us to 2013. Notices can be filed 10 years before termination, so it is becoming ripe right now. We are focusing on works that were created after January 1, 1978. Now, don't worry, if you have older works, you can still terminate them. That's then governed by Section 304. Those actually have a 56-year period before you can terminate them. And because sound recordings didn't get copyright protection until 1972, 56 years after that, it's 2028. So we're actually in a circumstance where the later works after January 1, 1978, are going to become ripe for termination before the earlier works. So now critically, and I'm going to quote here, the termination right applies to, quote, any work other than a work made for hire. So if a sound recording is a work made for hire, the transfer can't be terminated and the label retains ownership. If a sound recording is not a work for hire, the transfer can be terminated, and the author or the author's estate will regain ownership and can negotiate better terms. Now, obviously, this only is going to have an impact on those very, very successful recordings, those recordings that after 35 years still have value. So really, we're talking about fewer than probably 1% of the recordings that are released, but it's a critical critical income, and it's a right to protect that very portion, because artists didn't know when they were selling their copyrights that they were going to be in that top, 1/10 of 1%. Now, as an aside, while this is a new occurrence in sound recordings, and you probably hear the record labels talk, yeah, it's disruptive, we won't know what to do with our business models. It's not disruptive, and it's new for sound recordings, but that's because sound recordings only received copyright protections in 1972. Other types of copyrighted works, like novels and musical compositions, have long used the termination rights. Those industries work fine, they continue to prosper, it's just a part of business. So, well, can a sound recording be a work for hire? So now we have to go back to the definition. First, if it's an employee. Now, the Supreme Court actually considered this in a case called Center for Creative Nonviolence versus Reed, and they went through 13 factors. They're basically the agency factors to determine whether a hired employee is an employee. A hired employee would count as an employee under the first prong. And those are things like whether there were taxes withheld, whether the hiring party had the right to control the manner and means of production, who owned the sources of the instrumentalities to make the work, where was the location of the work done. I don't think that under this prong, recording artists, or featured artists at least, don't fit under this prong. Also, quite frankly, don't think that the record labels would ever claim that they do. And so far, I've yet to hear them ever claim that they do, because they would face serious tax consequences and Social Security consequences because they haven't been paying, their share of FICA or withholding taxes, and so for, throughout history. So they would have a major liability, and I don't think they're going to make that claim. So the real crux of the issue is whether a sound recording fits into one of the enumerated categories in the second prong. As I said, sound recordings are not enumerated categories, but compilations and collective works are. Now, the record labels are going to claim that they're compilations or collective works. That's, I think, fact-specific. I think that would be a weak and losing argument, but David's going to discuss that, so I'm done with that discussion. But the other thing I want to point out that people often forget is if sound recordings are considered a work for hire, we're in violation of our international obligations. The WIPO WPPT Treaty of 1996, to which the U.S. has adhered, requires that we give performers on phonograms certain rights. And if it's a work for hire, we have not given them those rights, and it would put us in violation of our international obligations. Seeing as everything is, I think, the record label's position is pretty weak, they tried to fix it and strengthen their position, and I'll pass it on to Jay so he can tell you what they did.
This is fun, actually. I made a very good friend as a result of this, Ann Chadovitz. I first met her when we were dealing with this issue in Washington, D.C., as Ann Chadovitz and Patricia Pollock assaulted me and said, you know what's going on here? So I had to learn what was going on. Here's what happened. In a bill passed in 1999, which was approximately a 1,000-page bill, called Omnibus, it was an Omnibus, what was it? Omnibus Reform Act, that's right, Omnibus Reform Act in 1999, which included many things concerning satellite and everything else except the record industry. And somehow, some way, the RIAA convinced the committee, the Judicial Committee, or a subcommittee of the Judicial Committee, that they needed to make a little technical amendment. And could they include this little technical amendment in this act? And they said, well, you only have to add 4 words, as a sound recording. And Howard Coble and everybody else on that committee said, well, sure, that's a technical amendment. They said, sound recordings have always been work for hire. Take a look at our contracts. It says work for hire. And somehow it didn't get in the act. And so would you add those 4 little words? Under the guise of a technical amendment. Well, it was added. And so now all of a sudden we got a 10th category. Sound recordings is considered as a work made for hire. Shortly thereafter, I was alerted, and I can't remember exactly who made the call. There was a Margaret Cohn that was involved. There was Ann Chadovitz was involved. Patricia Pollock from the AFM was involved. Somehow, I received a call. And I just can't remember who made that call to me. And they said, you know what happened here? And so they said, we got to do something about this. And Don Henley got involved, and Irving Azoff got involved. And they said, can you get Cheryl Crow involved? So I made a call to Cheryl, and she said, yes, of course, this sounds horrible. I explained to her what the consequences are, with the consequences being that you can't recapture the ownership of your work of authorship. Interestingly, and we'll get into this in more detail, it says that the person who has the termination right is the author. There is no definition of author in the Copyright Act to that extent. So we're going to get into what that means. At any rate, what happened then was a number of people, the AFM, AFTRA, a number of artists and all that, started flooding Howard Coble and Howard Berman with telephone calls about this and claiming that this was really a substantive change. And Mary Beth Peters from the head of the Copyright Office agreed that it was really a substantive change. She wasn't so sure before, but now she was sure that it was a substantive change. And so we convinced or everybody together convinced that subcommittee to hold hearings on this because it was a substantive change and we needed to really have a hearing on this. So they called for hearings in the spring of 2000. I convinced Cheryl to go back and testify. Mike Green from NARIS, he was going to testify. We had a professor on our side, Marcy Hamilton, agreed to testify. On the other side, Hillary Rosen was testifying to the other side. Mary Beth Peters was going to testify. They had a professor, Paul Goldstein, was going to testify on the recording company side. And so we all marched to Washington. Cheryl was going to testify. I wasn't initially supposed to, but she asked me if I could sit there and answer questions because she didn't feel confident to answer the questions that may come from this committee. So I went there to do that, and it turns out I got to speak a lot at that time, which was kind of fun, I must say. At any rate, it became clear during the hearing, after everybody was testifying for and against, it became very clear to Howard Coble and to Howard Berman that this was indeed a substantive change. They seemed to be somewhat embarrassed by the position that they were put in at this point by the RA.
Politicians, Jay. How can they be embarrassed?
True enough, but they actually expressed that. I was really surprised myself that they were caught here in this position. They didn't want to be caught in the position. So their solution to getting out of this thing, because they said legislation would be very difficult, how do we handle this thing? So somehow they came to me and Kerry Sherman, the general counsel for the he's now president, but he was general counsel for the RA at that time, and they said, we'd like to see you. So the two of us went in a small little room, and they said to the two of us, we don't want you to leave this room until we get this solved, this particular problem solved. So at that point, I seemed to be, without portfolio, the designated hitter for AFM and for AFTRA and for the Music Managers Forum and for NARIS and all the people that were involved to go to this room and sit there with Kerry Sherman and try and work out the language. And then, of course, running everything by everybody was there. So we sat there for several hours. Then we were called again by the two Howards, and they said, well, we're making some progress, but it's very difficult. We need a little more time. They said, okay, we'll give you 2 weeks. And so I went home, Kerry went home, and we started communicating over the next couple of weeks, and I was communicating with all the other the other parties. Now, what RA was concerned with, first of all, they were embarrassed themselves, and they liked to have their clout with that particular committee. And so now they had a bad name with that committee, so psychologically they knew they needed to do something. And we were able to take advantage of that fact. So we worked out language, but RA was concerned that if it was simply a repeal, that would establish the fact that for sure that a sound recording could not be a work made for hire. So we had to work out very carefully drafted language, which is in the Copyright Act now, that the fact of the repeal, the fact of the adoption and the repeal really says nothing about ultimately the status of whether a sound recording could or could not be a work made for hire. Because we all know that the RA is going to take the position, or the record companies will take the position that in some category, whether it's a collective work or a collective work or a compilation, that it is a sound recording. That's going to be their position at some particular point in time, amongst other defenses. So we worked that out very carefully. Now, let me point out a couple things. In 1978, so that means in 2013, which is really upon us, that those copyrights will go back to the author. Now, a lot of people have written and said that, well, there's not that many records that would be important, and so it'll only affect a few. I want to read you some of the recordings from 1978 and 1979 that are coming up in 2013 and 2014. The album Van Halen by Van Halen. I'm just going to skip a few of these. Blondie, Parallel Lines. Bruce Springsteen, Darkness on the Edge of Town. Talking Heads, more songs about buildings and food. Judas Priest, or The Killing Machine. The Ramones, Road to Ruin. Bob Marley and the Wailers. Babylon by Bus. Let me give you a couple other of these things. AC/DC, Cheap Trick. The Rolling Stones, Some Girls. I'm going to give you some for the following year. Some of them are even bigger than that. The Clash, London Calling. Neil Young, Rust Never Sleeps. Pink Floyd, The Wall. Elvis Costello, Armed Forces. Talking Heads, Fear of Music. AC/DC, Highway to Hell. Frank Zappa, Joe's Garage. Michael Jackson's Off the Wall. I think I have a few more.
Are there any important?
Nothing important.
Funky Town.
Ricky Lee Jones.
Funky Town.
Funky Town. Fleetwood Mac, Tusk, Cheap Trick. Tom Petty and the Heartbreakers, Damn the Torpedoes. Another Bob Marley and the Wailers, Survival. The Who, The Kids Are All Right. Supertramp, Breakfast in America. Ricky Lee Jones.
Basically my record collection, basically, in vinyl.
George Harrison. I have the list is amazing. What's on these lists? Like obviously we don't have time to read them all. This is a vitally important issue that we have to get into, and we're going to get into the idea of, and I guess it'll be after I talk here, the idea of who is the author, which is going to raise an incredible amount of controversy, is a very interesting subject, but I think that's my time for that.
Great. All right, good setup. So, David, would you please lead us in an understanding of the challenges to defining authors and authorship?
Good, yes. Let me start off by saying that if we wanted to address this issue sensibly, then Congress would tell us what its intent is about the terminability of sound recordings. Now, the only time Congress addressed that was in 1999, which it then took terrible pains to recant in 2000, as Jay told us. So that's a wash. Congress said something and then it retracted everything it said. What we're left with is a series of amendments that are inconsistent, that do not squarely address the issue, and basically put us in as uncomfortable a position as we can be in. Why is that? In 1965, a bill was cobbled together and universal agreement was given to it. That had the enumeration that Ann told you about, which did not include two very significant categories of works that are typically undertaken by a group of individuals. Those two categories are computer programs and sound recordings. It's obvious why they weren't included in 1965, because neither of them were subject to copyright protection. It's also obvious why Congress did not include computer programs in its enumeration when it passed the ultimate law 11 years later in 1976, because at that time, computer programs still were not subject to copyright protection. That didn't come until 1980. So the big question we're left with is, why, from that bill in 1965 until the time the law was passed in 1976, didn't someone add sound recordings? And the answer is because everyone was asleep. The bill was put to bed in 1965. It had an 11-year incubation when two controversial issues were worked out. Jukeboxes and cable television has nothing to do with the fact that sound recordings were added in 1971. So already we have the seeds of the disaster laid in 1976. Now, Jay mentioned to us the Blondie Parallel Lines album, which is a wonderful example. My colleague Peter Manel at Berkeley and I take that as a perfect illustration because the contracts, such as they were signed before the 1976 Act went into effect. They were signed in 1976 and 1977. Some of the tracks were laid down in that era. So if you look at those would be subject to termination 56 years later, and yet the album came out in 1978, so that's seemingly subject to termination 35 years later. So what do you do with such a mess? Well, the first question you have to ask, as Ann told you, is, does the work qualify on a basis other than sound recordings? You can't get it to qualify under sound recordings because that 1999 amendment was rescinded. So the first obvious candidate is a compilation. Now, you often hear a statement, on the one hand, every single sound recording is a specially commissioned work for hire. Or, on the other hand, 0 sound recordings qualifies as a work for hire. I'd like to reject both of those extremes. Here's an example of what I think could be a specially commissioned work for hire as a sound recording. Let's say Mark were to say, I want to get various people to re-record Beatles songs, and I'm going to hire Beyoncé to sing Yesterday, and Alicia Keys to sing Blackbird, and Eminem to do Why Don't We Do It in the Road. That would be an album that would be a compilation of pre-existing musical compositions, which in my estimation could qualify as a specially commissioned work. That is the type of compilation that Congress had in mind. What Congress had in mind classically is an encyclopedia where various individuals are hired to write an entry about France, about England, about Louis XIV, about Henry VIII. Okay, that would be a compilation that is not subject to termination. So this hypothetical album that I'm just making Mark the impresario of Beatles songs re-recorded by current stars, that would be a compilation that would be subject to that would not be subject to termination. It would be a specially commissioned work for hire. Now we ask Pink Floyd, The Wall, is that a compilation? Well, I guess one could argue on the surface it is a compilation. It strikes me that it is about as much a compilation as a novel published the same year, Gravity's Rainbow by Thomas Pynchon. Might be that Gravity's Rainbow contained 13 chapters. It might be that The Wall had 13 tracks on it. Neither of them is a compilation in the way anyone intended to use the term. Rather, Gravity's Rainbow is a continuous narrative broken down into chapters. Pink Floyd's The Wall is a continuous story broke up into tracks. And so I don't think that the reasonable interpretation is that either of those works would be a compilation as a specially commissioned work for hire. And once we determine that, that means that they both are subject to termination. So now we get into the realm of headaches. Who is it that is able to terminate Pink Floyd The Wall or Blondie Parallel Lines? Well, it's the authors. In the case of Thomas Pynchon, it's probably obvious that it's him and not his editor and not the person who wrote the blurb and not the person who took, well, you don't even have a photograph of Thomas Pynchon because he's a famous recluse, so there's no photograph
There
there.
actually, there's 3 photographs, but they
There are 3
predate the book,
photographs?
yeah.
Okay, well, they're not on
Days
the
of
book.
Cornell, yeah.
Okay, so the question becomes, who can terminate Blondie's Parallel Lines? Well, I think at one point I analyzed it thoroughly. I think there were five performers in the band. But in addition to that, there are backup musicians, and there are vocalists, and there are sound engineers. And if Phil Spector had been involved with getting a wall of sound, there would have been a very serious record producer. But it wasn't Phil Spector, but it was somebody who was known at the time who did produce Blondie's Parallel Lines.
Mike Chapman?
Yeah, Mike Chapman, exactly.
Who was
right,
well
right.
known at the time.
Right, that's right. He was very, very well known. So the question becomes very simple in the case of a literary work, very difficult in the case of a sound recording. The only parallel you could look at is a motion picture, which also has 1 million people involved. That issue is solved. Congress said an audiovisual work is one of those 9 categories that Ann talked about, and every studio is extremely careful to get every single person to come on the set to sign a specially commissioned work-for-hire agreement, except for Mr. Al-Muhammad, who I'll come to in a few moments. It's very difficult to know. In the abstract, it could be that Deborah Harry, is that right?
Deborah Harry, yeah.
Deborah Harry has the right to terminate, and let's say that she's earning 10% of the royalties right now, and she thinks, oh, that's 10% is pretty bad, I want to get 100%. So she starts to terminate. Then everyone else, Mike Chapman, the backup singers, the four colleagues, the studio musicians, the guys who are controlling the knobs, the record producer, they all get on the bandwagon. Now we have 20 notices of termination filed. So now Deborah Harry said, well, I used to get 10%. If all 20 of these are valid, I'm only going to get 5%. So I don't really like the way that things are hanging up. And it's probably the worst result we could think of. It's very bad for the record company. It's very bad for Deborah Harry. I guess it's a windfall for these backup vocalists. But it's probably a situation that no one would have intentionally gone into had they had their eyes open from the beginning.
And I just want to, I don't think the situation is that bad. I mean, nothing personal, but that's the argument that Hillary Rosen made in 1999
Yes, she
about
did.
the Parade of Horribles and
Okay,
nothing personal,
well,
but I
actually-
just wanted to go through a
hang
bunch
on,
of
Ed.
things.
So tell me why we immediately throw 19 of them
Right,
out.
well, okay, that's what I was going to get to. First, a variety.
Well, let's get to it
of things.
now.
Okay, they have to contribute something of authorship.
Correct.
First of all.
Right.
And I don't think that everybody that you just listed actually did contribute something of authorship, and I think that the courts found that in the case that you mentioned, that, I can't pronounce his name.
Okay,
That wasn't actually a contribution of authorship. That's one. Another thing is I think a lot of these works, and this is where it's going to get even more complicated, are works of joint authorship where part of it is a work for hire capacity. I think a lot of these people do fall under the employee prong, or the first prong of work for hire, the session players and
Okay,
things
good,
like that.
good.
And then,
Okay,
wait,
hang on.
then,
Let's just take them one at a
But
time.
David, stay organized. That's good.
The point about Al-Muhammad is a point I want to get to. Before the Ninth Circuit ruled in a case involving the picture Malcolm X, it was always assumed that the record producers and the sound engineers and the backup musicians and pretty much everyone involved in a production who contributed to authorship is going to be a joint author. And absent an agreement among them, they all own an equal share. So Deborah Harry gets in, and she's the star. There's a backup bass guitarist who plays 3 licks. Each of them owns 50% unless they have a written agreement between themselves. But then there's the Al-Muhammad case that we'll get to in a moment. So I would have said the background law is everyone has an equal share. But let's talk about what you raised, which is a fascinating point. You think that Deborah Harry had paid employees who worked 52 weeks per year as background guitarists?
no, but I think those guitarists were freelance employees, not independent contractors. I think, they were told where and when to report, what to do, very different. She provided the tools, she rented the studio, very different from what the featured artist does. I came from the union, I know taxes are withheld.
Okay,
They're paid very differently. But I think where that gets really interesting is what does that do to the terminability of the whole work? Now, I think, and this hasn't been decided, I think that the non-work for hire portion should still be terminable. Under the actual wording, and I had some interns, try and do this, and there are no cases, it says the termination right applies to any work other than a work for hire. Now, there is, a law student wrote an article that said that goes to an attribute of the work. So if any portion of a work is a work for hire, then nobody can terminate the non-work for hire portion of it. I don't think that's right, and I think that intent flies in the face of what Congress meant. But I think that's something that we do have to consider, because I think most of these works are joint authorship.
At the risk of committing suicide, by
I'll protect you from either. Right?
by partially disagreeing with David Nimmer. The real problem is that every record is done differently. I represented for a very long time, you should pardon the expression, Phil Spector.
You still resemble him, sir.
When Phil produced a recording, and I was around a lot of those recordings, Phil went in and he did what he did by telling everybody what they should do. He told the guitars what he wanted, he told the French horns what he wanted, he told the background singers what he wanted, and when he was finished amassing all of these tracks, then he would go to the singers, be it Bill Medley and Bobby Hetfield, or the Crystals, or the Ronettes, or whoever they were, and he brought them into the studio like another instrument. And he said, do this, do this, do this, sent them all home, and then sat there for the next several months or year and put it all together and came out with his recording. Now that's very different than when Bruce Springsteen goes in, who is the performer themselves, and maybe they have a co-producer or not, and Bruce Springsteen calls in everybody, or he hires union musicians. The union musicians, I was one of those at one time, signs a form, the taxes are deducted, you work for a lot of employers, you're a union musician, you sign this thing, you're an employee, they deduct the taxes, you get all these W-2s at the end of the year as a musician, so you're an employee. Each situation here is so vastly different that I don't know, and this is what's fearful about this, quite frankly, that when we arrive at 2013, I don't know how we're going to come up with one rule that satisfies all the ways recordings are made and the way musicians are hired. Some are union, some are non-union. And the background singers, some are union, some are non-union. The producer, most of the producers these days are hired by the artist, not by the record companies. At one time, record companies had producers on staff. Warner Brothers was one who had some of the greatest, as well as Capitol, producers on staff who produced the product. Now that's not true. All these are independent.
Actually, it's interesting how what's past becomes present. And you look back at what was happening in the 40s and 50s when A&R people at record companies would put together an idea for a record, get the writers and the staff producers, and then have the artists come in and perform, like Jay's talking about. But we have a lot of that now. I mean, not trying to diss any big-selling artists now, but I don't think anyone really believes that, Hannah Montana is playing, Bruce Springsteen when those records are recorded. And Lou Pearlman made a lot of money basically telling artists exactly what to do and treating them, and they were employees in that case. Point being that...
Treat them like crap, actually, what he did.
Well, those of us who actually been... I was a union member, too, and I can remember some of the crap that people asked me to do, and that was fine. I was a good junk keyboard player, so I needed some special effect. It was like, call Goldstein, he can do that, and that was fine, but I had no creative input. Point being, though, that this issue that Jay's brought up is not just ancient history, and it's not just Phil Spector who's is what he is. There are a lot of records being made now. There are a lot of records that were made in the 90s, even in the 80s, that were made in a very controlling fashion by record companies, while many of the records...
That's Phil calling right now.
Many of the records that are really important weren't made that way. On the other hand, just to go back to the list that Jay told you about, and I was just taking some notes while he went through it, those are great records. But as I'll talk about later on, if you look at Bruce Springsteen, Bruce already has reversion right for his records in the deal he cut with Sony, when it was CBS before that. Neil Young gets his rights back. The Rolling Stones own the rights in their masters already. Elvis Costello owns the rights to his. So a lot of the artists we're talking about that made records that are real important and would be an issue in this work-for-hire, termination rights, how does it fit together? So it's already an issue. It's an issue that's been negotiated. It's an issue that's being worked out as a practical matter now. And
what about the producer? What about the producer?
My point is, which is why the real issue here is this joint authorship issue. and how you're going to resolve that. When I talk a little later about what comes up out of that, it's a practical matter, we'll see that we could get into a place where it really is a total free-for-all.
I just want to say one.
Everybody can terminate. Then instead of having one set of exclusive rights, you could be in a situation where you have 20 sets of non-exclusive rights, because if you're going to terminate as a joint owner, you can't exercise rights in a way that's exclusive. All of a sudden, the rights everybody has are worth a lot less, and everybody has a smaller share. So it's not in anybody's interest to go in that direction, unless, in fact, you're getting nothing now, and now you're going to get a very tiny share. In that case, it's in your interest, but that may not be, and it's not likely to be, the people who are going to drive the track down which this train goes, or drive the train down which the track, whatever, you get the idea.
But I just want to say just a couple.
I'll move it closer.
Use your mic.
I just want to say a couple fast things. I think what you and Jay said is actually the reason why sound recordings weren't included in 1972. It's not because people went to sleep. It's because at that point, the labels were authors or joint authors. They had producers on staff. They owned the studios. They picked out songs. They were much more integrally involved. And things changed, and all of a sudden, they were no longer an author. So we're trying to find a way now to make it a work for hire. And the other thing, when you just brought up this Darkness on the Edge of Town, well, you said Bruce Springsteen. The album that Jay talked about is Darkness on the Edge of Town. He may now have the strength to negotiate his reversion rights. He didn't when at that point.
But even before,
that's part of the issue.
But he did have the rights to do that before 1999. He went back and he negotiated, when he had renegotiation with CBS, one of the things he got was he got a reversion of the rights in his existing masters.
But that's because they still wanted him.
No, I
a
understand.
lot of artists
I understand that. And I'm just going back
don't
to the
have
point.
that
I'm
ability.
really, I think, agreeing with the point you made before, which is that in other industries, this has been an issue for a long time, and parties have worked out a way to deal with these things. And the analog we have in the recording industry is that there have been, are now, and will continue to be, unless the whole business collapses completely, at least with respect to selling or monetizing recorded music, you'll have artists who have enough bargaining power to be able to work out the fact that they either own their masters or get them back at a period of time. And the record industry hasn't collapsed, and oddly enough, I'm being facetious, obviously, oddly enough, the people who have the clout to be able to negotiate those kinds of clauses, those kinds of provisions, tend to be the most successful artists. And while it's true that if you look at what happened to the record business over the last 10 years, you say, oh my God, the record business is falling apart. I'm not here to argue, nor is anybody, any record company, that the reason it fell apart is because Bruce Springsteen had the bargaining power to come in and get the rights to his records back, or the Rolling Stones, or even Elvis Costello. No, that's not the point. The point is that the parties can work stuff out as long as there's a framework that provides for a way to work it out where the parties can have a sense of what their rights are going to be. And the thing I fear about the uncertainty of the current state of affairs in works for hire termination rights is you got joint author issues and you got people who can run around and bring in a claim. It's going to be very hard for anybody to predict, control, accurately evaluate what the numbers are going to be for those rights before you see what comes in. Not saying that we shouldn't, that there's some God-given right that sound recordings be works for hire. Honestly, I don't think anybody at a record company now, if you got them not on a stand in front of a Senate committee, not writing an article pro and con about this issue, nobody seriously believes that the way the law looks now, that all the records that were made pursuant to contracts that say that those recordings are works for hire are going to be works for hire. Some of them will be. Some of them will be the kind of record that David mentioned before, which I'm expecting to receive massive royalty checks for any time now. And there are going to be some recordings that were made in a fashion where there was real control. There may be records where it's all studio musicians and their union contracts and their employees.
Well, let's go here for a
Okay.
second. David, I want to make sure.
Should I go out to the
Yeah,
Alamo?
we can talk about how it can be resolved by deal making, but how about some of the precedent that's being established? Like,
Can I ask David one question on something he said? David, you said that if somebody goes in and they record a group of songs by the Beatles, that could be considered a compilation. Doesn't it depend upon who's doing that and at what instance? For instance, isn't that if I don't know, pick any name. Somebody goes in and they record a bunch of songs by the Beatles. It's not the songs that are the the criteria for the authorship. It's the authorship of their sound recording. And if it's one author, I mean, if it's one performer doing songs of the Beatles or one performer doing songs of 10 different people, I don't see any difference to that. To me, it seems like that's still the performer and maybe the producer and maybe others, maybe the authors of that, but not the company as a work for hire, unless the company, like they do sometimes with Christmas albums, they'll come in there and they say, let's go put a bunch of Christmas tracks together and put out an album. And then maybe they are the author of the compilation, but not necessarily the author of the individual tracks. David, can you comment on that?
Well, I mean,
I was going to say, it's the impresario. I really disagree
the album
with
that I put into Mark's hands was essentially a Christmas album. He's hiring different individuals,
Okay.
and he's inspiring them to make
Not only that,
new
I'm
sound
telling
recordings.
them what
Right.
songs to record, and I'm maybe even giving them the arrangements, and I'm putting it together with the producer. I'm hands-on.
You're
here.
the
I'm an
you're the
impresario.
mastermind
I'm
under
making
the
this work.
Right.
Al Muhammad case, right?
Exactly. Right.
And again, if you look at compilations or collective works, you know, they can be collections of things that are, depending on which of the categories you're talking about, of otherwise individually copyrightable works. So I think we're saying here is that that album, again, which I expect to receive massive royalties from, the album itself, it really does look like it's a compilation, because I've went out there and I've individually, commissioned people to give me a track on terms I want, and I've said, here's what the song is, here's the producer, here's the style I want.
That type.
Deliver it, I'll put it
Exactly,
together.
exactly. Now, on the other hand, if Justin Timberlake has the idea that he's going to record 10 songs by Cole Porter, that sounds to me like it's not a compilation, so it's not eligible to be a specially commissioned work for hire. Now, I happen to agree with Ann that at the era of the 1970s, record companies had employees, just like motion picture studios had employees, had composers on staff. So they were actually bona fide employees. But the motion picture companies were very careful to get a category under prong 2, the specially commissioned works, so that audiovisual works qualify, especially commissioned works for hire. The record companies did not do that, and that's exactly why we're in this pickle we're in today. And I agree with Jay that it's a case-by-case determination. If there were 20 people, and the easiest surrogate for figuring out their status is, did they get a W-2? So if 12 of them got a W-2, then it seems to me that 12 of them worked on a work-for-hire basis. So now we're down to 8 people. Ann identifies a very vexing issue. What is a work that's created by 12 employees and 8 individuals who are not employees? In my piece that's in the contribution that's in your materials, I say you can look at it one of 3 ways. You could look at the whole thing being subject to termination, or none of it subject to termination, or the parts are subject to termination that were made by non-employees. And that third point of view is the one that I think is the most sensible. So I think in that situation, on a case-by-case basis, 20 people went into the studio, 12 of them were employees who received a W-2, and were basically working all year, not piecemeal, case after case, and 8 of them were not, then those 8 individuals in that concrete case can terminate. But even that is going to be a difficult situation, so what do we do about it? Let me tell you very briefly about the Al Muhammad case. When the movie Malcolm X came out, it turns out that every single person, every grip, every star, every writer, every composer, everyone signed the typical work-for-hire agreement except for the Islamic consultant, Mr. Al Muhammad, and through inadvertence, he wasn't asked to sign something. So, invoking good copyright doctrine, his lawyer said, well, it's very simple. There are 2 authors to this movie. One is Warner Brothers, and the other is Mr. Al Muhammad. So Mr. Al Muhammad owns 50% of the royalties from Malcolm X. Okay, well, that was a dilemma that was posed to the Ninth Circuit, so they reached back and said, well, that can't be the case, so we're going to say that the mastermind owns this. And here it was Spike Lee, who was an employee for hire of Warner Brothers. So you could do wonderful things with the mastermind. You could say, it's only Deborah Harry, or you could say, it's Deborah Harry and Mike Chapman, or you could say it's the 5 of them. Unfortunately, there's no case law about that. And the dilemma further is, even if we start litigating these cases and 10 cases get decided, we're still going to have very little guidance on a case-by-case basis for other properties that were put together under a different scenario. So one could lean very, very much in favor of recording artists by having a very tight definition of mastermind. That's one way the law could go. Now let me lean the seesaw over the opposite direction completely. One could rule very, very strongly in favor of the record companies by an aggressive interpretation of part of the termination for transfer doctrine. and that's the famous derivative works exception. So that when Cornell Woolrich writes a story, It Had to Be Murder, and it's made into a movie, Rear Window, after termination of transfer, only Cornell Woolrich's heir can authorize a new version with Christopher Reeve to be made of the movie Rear Window, but Warner Brothers can still exploit its work in the can. Now, in some sense, sound recordings are unique in the copyright world in that they're all derivative works of musical compositions. Now, not every single one. If I were to go outside on Wilshire Boulevard and record traffic, that would not be a derivative work. But every record you're likely to buy is a sound recording which is a derivative work of a musical composition. So one could be very aggressive and give an unprecedentedly large interpretation of the derivative works exception to say, fine, Deborah Harry has terminated. She owns the rights. That means in the future, if she wants to make a new sound recording for Parallel Lines, she can do it, but the record company owns the existing derivative work and can continue to exploit it. So I doubt that either of those extremes will be the solution that the law alights upon, but it's undoubtedly going to be something in between those two.
Yeah, I'd like to respond to that comment for a second. I think that derivative works could be a concern, but I don't think it's this kind of concern. I don't think there's any way in the U.S. a sound recording would be deemed to be a derivative work from a musical composition. For example, we have mechanical rights that apply to sound recordings, but they don't apply to derivative works. And that's making a sound recording of a musical composition. You can get a mechanical compulsory license to do that, but not if it's a derivative work. Therefore, sound recordings are not derivative works. Sound recordings in the U.S. are separately copyrightable. Also, and you don't need permission, which you would for derivative works. Unlike, in many countries where they have a neighboring rights regime, a sound recording isn't independently copyrightable. It's deemed to be a neighboring right to the underlying musical composition. I think that argument would hold a lot more water than it will in the U.S. But I do think that derivative works could raise its head in this debate because I do think that the record labels are still, okay, I'm paranoid. Call me paranoid, but you know what? When the RIAA is on the other side, it's like just because you're paranoid, they're not out to get you. So I think, they tried in the two versions of the Pro-IP Act ago, like 6 months ago, they tried to put in a provision to up the damages available on each component of a compilation. The Copyright Office actually asks them, why has the statutory damage limit ever hindered you? Have you ever wanted to get more? Dead silence. Tell us when. No reason why. The true compilation, people like publishers, magazine publishers, they didn't want it. So, of course, as soon as I heard why, well, they wanted it because it was going to go with legislation that said because a sound recording is a compilation, they have to get damages on every track. So they are still trying to sneak this in various ways. An issue right now that's happening is, sound recordings that are pre-1972, when they're played on the air, on a digital service, does that digital service have to pay? Record labels, artists, everybody thinks they should have to pay. But sound recordings weren't copyrighted until 1972. So what is the record label's argument? Well, they argue, oh, it's a derivative work. That's why when we made the CDs in the 80s, we mastered it, and we remastered it, and the CD release is a derivative work. Well, if artists were ever to buy onto that, or courts buy onto that, under this, you cannot terminate a derivative work. The derivative work can continue to be exploited under the terms of the original grant. So if that were to happen, even if sound recordings are deemed to be not works for hire, they're virtually worthless because the record labels could continue to exploit the CDs. So I do think derivative works may be an issue. I don't necessarily see it in the same way, but I also think every artist representative needs to look at every thing that comes across your desk with a fine-tooth comb, because they're still trying to sneak things by.
So we have a,
And I would just one thing that recently there's been several challenges to pre-72 recordings, and it's been by the satellite services who have challenged that, very definitely challenged it, and say that they shouldn't have to pay. They pay pursuant to an act, as you probably all know, in 1995, I believe it was, when they came in a performance royalty for webcasting and for satellite radio and satellite television, et cetera, where a performance right for sound recordings finally came in. There was no mention whether this is pre-72, not 72. It was for sound recordings. And so Sound Exchange, which has been collecting this money from the services and then distributing it the money, and the question has now been now posed by the satellite services that they shouldn't have to pay for pre-72 recordings because they're not, in their estimation, covered by the act. That's going to be a very interesting question. It's an unresolved issue, but it's certainly a challenge right now.
so let's talk about resolving some of these issues. We've thrown up a lot of issues and a lot of argument about interpretation. David, do you, and Mark, I had asked you to maybe prepare some thinking on this as well.
We can all talk. I'm happy, because David and I both have to leave in about 5 minutes, so.
Yes, so go ahead, Mark.
Yeah.
No, just one thing I'd like to say is derivative works, in fact, can be copyrighted separately. In fact, they are. Okay,
Yeah,
so,
they're-
but, and there are a raft of cases out there that deal with termination rights when you're talking about compositions and who's entitled to get the income, where they get directly, where they have to get through the publishing company. I'm sorry. There's a whole raft of cases out there about termination rights in musical compositions, and dealing with the fact that, yeah, you got these sound recordings after there are derivative works from the musical compositions, and who's entitled to money after the termination right occurs, and the courts don't always agree, and that's fine, which is, I think, part of the problem. Record companies, artists managers, looking at all the issues they've got with sound recordings, have a lot of problems that they're trying to solve right now. And I just did, in the last week, an informal survey of people who are running business affairs at record companies, from the big monster ones to little independent companies, to companies that essentially are putting out music that their company loves, like Arhoolie or small niche music labels. And nobody at those companies right now has this issue anywhere near the stove, much less on the front burner. And that's not because they're incompetent. It's not because they're committing malpractice. It's because they got bigger issues to worry about. They're worried about how they're going to monetize sound recordings at all going forward. And there's a significant body of thought amongst a minority of people, but a large minority in the record industry, that at some point along the line, it may not be possible to rely on or to expect reasonably that you'll be able to actually collect money for people exploiting sound recordings for listening purposes, as opposed to putting them in movies or putting them in advertising, putting them in games, where you're dealing with actual corporations or companies rather than individual consumers. And hence, you see all these alleged, what we call 360 deals, where record companies are trying to get rights and get an income stream from something other than the sound recordings. And a lot of the companies, when they look at where they're making their money now and where they're going to make the money down the line, they can read the numbers, depending on who you talk to and which numbers you believe. Currently, record companies make anywhere from 30 to 50% of their revenues from catalog. And catalog includes catalog that is really popular and catalog that nobody's heard of. But as it turns out, as I was mentioning before, the catalog that makes most of the money, amazingly enough, is catalog that record companies aren't going to have the rights to for a long time anyways. In fact, some of that stuff is going to disappear before 2013 because of reversion rights. Well, companies know that's out there, so they do what every business does. They figure, how can we negotiate this? How can we work this thing out so that we'll be in a position to make money from it and make money for the artists and make it look like a good deal for them to come back to us? So you look at a company like a Rhino Records that does catalog development work for Warner Music Group, and you look at where they're making their money. They got all this catalog that they can keep exploiting, and they go back to artists and they try to work out deals with the artists. But, it's funny. The artists that you really want the most had the most bargaining power, so they probably have consent rights. There are certain tracks that you can't put together, or there are limits on how you can put them together. They may not be able to use outtakes without consent. Real stuff. And it's a bitch It's a real bitch to put together a package that you can sell new if you can't get those rights. So those artists have a lot of clout. And record companies realize they got to work around that. So they go back to the artists and they explain, we'll do this for a package, we'll do this deal on your existing records, we'll give you back ownership, like they did with Bruce Springsteen, if you'll give us some more rights here. Those are things that happen in the ordinary course. But they happen as long as you can figure out where the rights are going to be after you work out that deal. So you have a Chicago that during the latter part of their career was signed to Warner Records. And acrimony, they split up, Chicago goes off. But Rhino has some of that catalog, not all the stuff. Chicago got some of that stuff back from Sony because they were able to renegotiate their old CBS deal. And what happens? Rhino goes to Chicago and says, look, we can put all your catalog together. We'll do massive packaging. We'll do really cool stuff. We'll make it look great. We'll do advertising. And Chicago makes a deal with them. Didn't have to. It'd be just the same if they terminated those rights. But in the case of Chicago, we know that there were parties contract. We know who to go to. You know who to make the deal with. It works out better for everybody. Right? So the issue I think that record companies are looking at here is not so much that works for hire is a point that record companies must win on because, as I said, I don't think anybody seriously believes that on the law that work for hire is going to apply to all the records they've got, maybe not even apply to a majority of the records they care about. But they do want to have a sense that if we can go out and negotiate with the people that we know are going to be people that control the rights, we can get to a place that makes sense. But you can't do that unless you have some kind of clarification or legislation to deal with that. I was glad that David brought up the Rear Window case because there's a classic example of how a law that doesn't get fully clarified can lead to enormous inefficiencies because during the period of time, up till 2003, that Rear Window was an actual issue for people, and you had to, if you wanted to make sure you got the extension rights or the renewal rights from stuff that was assigned before the renewal rights kicked into gear, you had to go out there and find all the possible heirs and get them to sign off on the renewal rights because otherwise they would have a claim to that if the original author died before the renewal rights vested. Well, the problem was that you didn't know who those people were. And I can remember I'm working on movie soundtracks, and the people at the movie companies were running around going bananas trying to find when we did what was the movie? I've forgotten the name of it. That had the Queen song in it, the Bohemian Rhapsody. And the poor guys at Paramount were running around trying to find all the possible heirs who might have been involved with Brian May. Fortunately, Freddie Mercury was a less difficult issue, but they were going crazy, and eventually you have to take a risk. Well, that's not an efficient way to do things. So I think what we have to clarify is who we're talking about as the authors. And back in 2000, when we had the hearings that Jay was talking about, Mary Beth Peters even talked about it then. She was saying the problem's going to be, we have to clarify that it can't be anybody who walked into the studio or took a phone call while the record was getting made, because that's not going to be a good result for anybody. And her approach was something we'll go to what Ann was talking about. We'll try to work with people who do something really, of a character where they exercise some artistic, creative control over what goes on. But that's still pretty vague language.
In parting, do you foresee a way to resolve the issue? Have you thought through what might be considered a global resolution that we haven't talked about thus far?
Well, the good resolution would be a legislative solution that everyone can agree to, but we haven't had it for the last 50 years, so...
I would love to see it too, but I'm not optimistic.
Yeah, and the seeds that exist in the law, they come from all these disparate statutes passed for various different reasons, and they're not terribly well suited for the sound recording. And I agree with Jay, it's going to be a case-by-case determination, and it's going to be very difficult as a matter of proof to show who had what rights. But that's what we're left with unless we can have a legislative solution.
Basically this, Mark, I think is more down than I think that we should be. Physical goods are going away. I agree physical goods are going away. Right now, this year, physical goods shipments are 50% less than they were 5 years ago, 50% less. However,
unit shipments, not dollar value, unit shipments.
Yeah, unit shipments, 50% less, absolutely. So we're going into, and of course, as you can see in everybody's neighborhood, the record stores are gone, with very few exceptions. Go to Amoeba, by the way, it's a great store.
Not one of Jay's clients.
Not one of my clients. we're going into a different business model, and the 360, we're not going to talk about the 360 here. I'm sure other panels are covering the 360, which is a repulsive name to me.
I agree.
So I don't want to talk about 360, but what I do want to say is that music is going to be sold in a different way. And
Well, be monetized in a different way.
it'll be monetized in a different way. It won't be the physical goods. It's going to be access, okay? Access. You all carry a cell phone. Everybody's got a cell phone, and you have access to certain things in that cell phone. You're paying one fee a month, and you get whatever you want. I think it's going to be the same thing basically with your content, whether it's the music content, whether it's audio-visual content, is all going to come via your cell phone. Not that you're going to sit there and watch it on your cell phone or your PDA, or you're not going to listen to it necessarily on that. Although I see people walking down the street all the time with their headphones on, which why don't you?
It's also repulsive.
Yeah, that's repulsive. Why don't you look at the sky around once in a while? At any rate, what is going to happen here basically is hidden in your telephone charges is going to be a charge for content. And you will be getting, because this is what the public wants. They want their music and their audiovisual content whenever they want it, wherever they want it. And you'll be able to, through that device, wirelessly, it'll go to your speaker system, it'll go to your television, wherever you are in the world, whether you're in a hotel room in Italy, whether you're in a hotel room or in Hawaii or your home. You'll be able to listen and view that content through that device. You will be paying a monthly charge, and then the big fight will be
I agree with that, and I would
division
say,
of the money.
I would say, just in response to that, just to wrap up what I have to say is, you may think because Ann and I disagree sometimes, I like Ann, and I would say that what Ann and what I would say that Ann could take away from Jay's point, which I think is a valid point, is the people that Ann should be worrying about aren't the record companies. They should be worrying about those phone providers. And I can tell you from having dealt with them and actually represented them a couple times, those people are animals compared to the record companies.
I agree.
Well, David, I know you got to go, so why
sorry.
don't you
I
make
have
your
to
exit?
also,
Great.
so-
Mark, great. You two remain here for a few more minutes. Give a hand to these gentlemen.
Always good to see you. Ann, good to see you again.
All right, Jay, you were riffing a little bit about what is the consumer angle and how that might affect the way the music is received going forward. Let's try to take that back into how is that going to impact this area of the law? How does the way that consumers behave? How do you think that might impact this area of the law? Because that actually might end up being what influences legislation, right? I mean, as a practical matter. So, and we heard David say that legislation is probably the best way, the more global way to resolve it, as opposed to a bizarre conga line of litigation. So let's talk about, do you have a way of connecting those dots for us?
Well, I mean, legislation, and I absolutely agree with David, that's the only way, but the problem is, no matter which way you turn in this thing, you run into a roadblock. Legislation. Okay, you're going to have diverse interests in that legislation. You're going to have the artists fighting for the artists. You're going to have producers fighting for the producers. You're going to have songwriters fighting for the songwriters portion. You're going to have the unions, possibly, I don't know, I haven't talked to them about this, maybe fighting for the background musicians and singers as to what their position will be. And everybody will go into Congress, and this is all going to be challenged there. And legislation is going to be just as difficult as sitting around in a room and trying to come to some conclusion on this. It is an extraordinarily difficult issue because we have so many diverse interests in this thing. Essentially, somehow it has to be the person who is and I don't know how you define this, it's not defined in the copyright law now, the driving force behind this on recordings. Is it the Bruce Springsteens? Is it the producer? Or is it the combination of the Bruce Springsteen and the producer ultimately? Because they are generally the creators. But on the other hand, you're going to have Clarence Clemens come in and said, oh, that saxophone solo I had on Bruce's song, that really was what everybody was listening to. Or Milt Bernhardt's trombone solo on Frank Sinatra's, I can't remember the name of the song. Anyway, that was the one that everybody listens to on that song. Those are the issues. I don't have a solution to this at this particular point because we all have such diverse interests in this thing. And I think over the next couple of years, we got to work toward that, and it's going to take a lot of us thinking together to maybe arrive at the solution.
So Ann, you've been, on the union side and been wrestling with this from a point of view of one party. So it's gotten you in the mix to follow up what everyone thinks and follow what Jay is saying. Do you see any common ground or way to resolve
Well,
this?
I've been, I guess, looking at it from, both the session players and the featured artist point of view, because, we represent both. But then also just from the creators and the policy point of view as well. I mean, I keep still going back to Congress's policy and the copyright policy of, rewarding artists by giving them, or the authors, a second bite at the apple, because they don't know what the value of the work is until it's exploited. And I think that we heard before, that, artists with a lot of power can privately negotiate rights back. But I think that leaves out a large portion of the people who this law is for, who really could, 35 years later, they're not doing this anymore. They had, 2 or 3 really big albums that are still worth something. And so they didn't have the clout to go into a second negotiation after 7 albums, or they left and went to a different label. So they have not negotiated reversion rights. And I think that we do need to protect them. Mm-hmm. And so I'm looking at it from the bigger point of view. And as for the solution, I agree with Jay and Mark that it's A, it's really difficult, but B, it's case by case, because not everything is the same. When you testified with Sheryl Crow, and she was great in the way, she wrote the songs, she recorded the songs, she did the package, she delivered a full master, everything. Well, that's very different from, even we talked about, Off the Wall was one on the list. Well, Quincy Jones had a lot to do with that, so that's different. Or, the Lou Pearlman bands, In Sync, those are very different. They're not Sheryl Crow.
Might it be defined by saying whomever is a royalty participant is, per se, a mastermind or a contributor?
That's one thing, the royalty participant. Sometimes, by the way, the engineers or mixers are royalty participants too, not once in a while.
But that recognizes the value
That
of the
could be,
contribution.
but maybe it comes down to the featured performer or the principal producer. Maybe that's when it's going to come down to. I think that's the practical way. I don't know if everybody's going to agree on that at all, but that seems to me, off the top of my head, those are the people at maximum who should get this reversion right, because they're the driving force behind the record. Generally, the featured artist, and the producer or co-producer in that particular case. And probably we should start or limit it to that, is my guess. That makes a lot of other people angry, I'm sure. But that's probably it. I mean, how about the songwriter? That's also, in many cases, the songwriter is there directing traffic as to what their interest is. I represent a songwriter that does that in the studio. Although he's not named as the producer, I can tell you with absolute certainty that that songwriter, when he writes the songs, he has a vision as to how it is recorded from beginning to end. I've seen it, I've heard it on tape, and he brings it in, and the artist does sing it, and there is a producer, but in this particular case, and it's not the only case, the songwriter is the one who created the whole package, the whole image, the whole concept was the songwriters. So maybe in that particular case, it's the songwriter. Mm-hmm. It is a very complicated issue that we all are going to have to wrestle with.
And one thing for you all, artist representatives, you be careful with what you do, and always think about this. For example, because I think artists have undercut themselves, those artists who are loan-out corporations. Well, then they're an employee of their loan-out corporation and makes it a work for hire, oftentimes for their loan-out corporation. So you really have to look at all the implications of things which are, and unintended consequences.
All right, it's 5:30, and I think we're going to have to cut it off. I'm going to commend to you the materials, which are quite weighty and good. We went over a little bit because that we were told to. But I would say if people have to go or want to go, you know, I was told we should cut it off now. So any other questions, you come on up and talk to our panelists that are here. Otherwise, we'll see you at the social. Thank you.